So as I was saying, we're covering estate planning today. If you have any specifics or want to follow up, you can contact me directly. I'll share my contact info at the end of the presentation. Um, from sort of the legal disclaimer side, I will point out we share a building with Everhart. So I'm based out of Central Ohio. I know a lot of the participants are spread kind of all over the country. So most of this information is generally applicable to your state and where you live. But some of the information, maybe Ohio specific. And if you have a question about other states or anything, I'm not licensed there, but can certainly direct you to someone if it makes sense. So, with all that background out of the way, we'll go ahead and jump into the content. As the title slide there says, we're covering Estate Planning 101 today, sort of what are the basics. If you have questions throughout, please pop them in the chat. Now that to fix the audio, I dropped off my phone. Bree will have to read them to me, but I'll have basically three different segments here. And when I get to a natural pause, we can read through any questions that she thinks make sense for the group and go over them. You can also ask questions at the end or email me or contact me directly. So let's go ahead and get in. This is a lot of content. I admit it's fairly dense. For the bit of legal background, of course, Jeff Kunklern, as you can read on the slides, I'm with Carlisle, Patchen, and Murphy. While not with Everhart, if you don't know us, we're a mid-sized full-service law firm in Central Ohio. There are roughly 30 or so lawyers who work here, and we do whatever it is you think law firms do. So people here do lawsuits and family law and employment and taxes and real estate. And then my specialty is estate planning. So wills and trust, powers of attorney, and then, helping people set those up and then administer them. That's all I've done for about 16 years now. We have a pretty big group here. There's about 12 of us who do what I do. So we've seen everything from the simple to the complex and everything in between. But let's go ahead and dive right in. So the goal today is to figure out what is an estate, what's your plan, do you need one? There are some sort of helpful tools that are do-it-yourself in here as well. But if we're starting at the ground level, if you got a plan for an estate, you first need to know what an estate is. And that's relatively rudimentary. It's really a balance sheet. So we sort of create two sides to your ledger. On one side, if we're planning for your estate, we need to figure out your assets, your house, your car, checking, savings. Presumably, since you're on this webinar, you've got a 401k account that Everhart helps manage. And then on the other side are your liabilities, your mortgage, car loans, etc. As a super simple example, if Joe had walked in and said, I want to plan for my estate, I'd first ask, walk through him, his family, any kids, spouse, etc. But then we dig into his assets. And in this case, he had a house, a car, and a checking account. That all went to one side. He wants to make sure, perhaps his spouse gets the house and a kid gets the car. And on the other side, he had some debt, in this case, a mortgage on the house. And so his net estate would be the assets on one side minus the liabilities. Well, what exactly do you do plan for an estate? Estate planning really falls into a couple of categories. The first one is what most people think of, making sure that when you pass away, whatever it is you have gets to whoever it is you'd like it to go to. And ideally, if you've done a good job, making sure that's really efficient. And that can be efficient from a timing standpoint, a cost standpoint, a tax standpoint. And that could be both during your life and at death. Most people walk in here and think it's only when I die. The reality is there are some important documents we're going to talk about this morning that take effect during your lifetime as well. If you happen to be one of the owners of the businesses who are on the call today, figuring out what happens with your business is really important too. Does that go to the other owners? Can your spouse take over? Does it go to your kids? So that can be really, really important with unique assets like a small business. And then certainly if we can, we try to reduce taxes. I do have 2 or 3 slides on taxes today, not the most exciting topic, but the estate tax can be fairly steep. So if it applies to you, which is a big if these days, then you want to make sure you can minimize them. And we do that as estate planning attorneys. Usually if I was in person, I ask for a show of hands, which doesn't work as well on a webinar, but the stats aren't great. When I ask people, do you have an estate plan? The unfortunate reality is almost 2/3 of people in our country don't have any plan at all. So no power of attorney, no will, nothing. And the numbers have only gotten worse. Back in 2011, it was about 57%. Now we're up to about 2/3 of adults who don't have any planning in place at all. And that comes from an article from Forbes that I'm going to use for sort of explaining why people don't have a plan. And the reason I like that article from Forbes is it approaches it kind of like Family Feud. I like game shows. And so they asked people when they were surveying, okay, do you have a plan or not? Yes or no? if you don't, why don't you have a plan? And I would say this very closely mirrors my experience and my practice that I see with folks. So the number one reason people cited was they just haven't gotten around to it. And I hear that all the time. People tell me I knew when I got married I should have written a will and a power of attorney. I definitely knew when I had my first child we needed to say in the will who raises my minor child. Maybe I knew when I became an owner of my business or when I acquired a certain asset or when I paid off my house or something that I should do it, but I just haven't done it. It's not urgent. What I always tell people is estate plan is kind of a unique area of the law where for most people, we don't know when we'll need it. So you don't know when you'll be in an accident, when you'll become disabled, when you'll pass away, but you don't get the opportunity to go backwards. So once you're in that accident or once you die, if you don't have a plan, it can really be a big mess for your family. And so for anyone who just hasn't gotten around to it, you really want to do it and put it on a shelf. I tell people all the time, it's sort of a break glass in case of emergency situation. You want a plan somewhere in your safe or on a shelf that if something happens to you, we've got something to work from. Then you just adjust that plan every few years or when life changes. Second most common reason people don't have a plan, they just didn't feel it was that urgent. I'm not dying tomorrow. I don't have a particular diagnosis or anything, so I'll get around to it when, I get older or if I get sick. That's great if you've got a long runway. For a lot of people, they pass suddenly, and so there isn't an opportunity to say, "Oh, I'm dying and I'm now going to make these hard decisions." And so you really want to cross it off the list and take care of it before it becomes an urgent matter. 17% of people said they didn't think they needed a will. I see this a lot for people who are either unmarried or don't have kids. They just think, I don't have anyone to leave it to. I'm not worried about it. The reality is, our laws are somewhat favorable for married couples and couples that have children. We make some assumptions in every state, including here in Ohio, where I'm at, that, for instance, if you pass, most of your stuff goes to your spouse. And if you and your spouse die at the same time, most of your stuff goes to your kids. And often that's the right answer. So it's even more important for those who don't have natural heirs, who don't have a spouse and don't have kids. And so anyone who doesn't think they need it, they probably actually need it more than those who do think they need it. 14% of people just don't want to talk about death. And I see that all the time. People who don't want to think through the difficult thought exercise. What if I'm in a really bad accident? What if my wife's in an accident? What if me and my wife and my daughter are in an accident? That's not a fun conversation, but it's an important one. And if you're working with someone like me, I try to make it as easy as possible. You do have to make some very difficult decisions and think about some hard topics, but it's an incredibly important thing. And I would say anyone who goes through the process, it's a huge weight lifted off your shoulders. You kind of crossed it off your list, you check the box, and you can breathe a sigh of relief that you've taken care of it. Who should have an estate plan? Anyone who's 18 or older should have at least some basic documents. And I will have at the end of this presentation something called my estate planning life cycle. I used to go through this hour spiel, and people would tell me, that was wonderful, but I don't know what I need. Can you boil it down? And so I've got the life cycle at the end of this. But if you're 18 or older, you need at least a few documents. And it doesn't matter whether you have a big estate or a small estate. Every estate needs to have a plan for who makes your medical decisions, who makes your financial decisions, who's in charge of your affairs, and who gets your property. So it doesn't matter whether you've got billions of dollars or you're broke, you do need to have some basic documents in place. I do a lot of pro bono work for the Legal Aid Society here in Columbus, where they send us people who have, virtually no net worth, but to them, they want to make sure they've got the right decision makers and that whatever it is they have, often it's just tangible property, or maybe it's pets, maybe it's not financial, maybe it's just physical things, that the right stuff goes to the right people. And then big ticket items, if you've gone through any of these things, if you have no plan, you probably need one. Or even if you have a plan, you probably need to redo your plan. If there's been a marriage, certainly that changes your circumstances. On the unfortunate other side of that, if your spouse passes away, you need to update your plan. Divorces create two people who need new plans. If you invite a new family member into the world because you have a child, that's an opportunity to do some planning. Also important stuff that people don't think about as much. If you inherit property, or if someone named, if your executor or your guardian or a beneficiary passes away, that's a good time to do it. And then if you move across state lines, you should at least review your plan. The reality is most states have some version of the uniform laws for both powers of attorney and wills and even trusts, but not every document works in every state. So if you do move, it's worth sitting down with a local attorney who's licensed there to say, is what you have fine, or do you need to get some new documents in place? There's some major benefits to planning in advance. First, you have a lot more control. You pick who's in charge of which things and at what timing they take that control. Second, you might save some money on taxes. That could be capital gains. It certainly could be the estate tax. Third, depending on what state you're in, probate court may or may not be a big deal. Here in Ohio, probate is fairly intensive. We have what's called supervised probate. So if you die with no plan at all or just a basic will, we have probate courts here in Ohio that oversee your estate. That tends to, at least here in Ohio, be pretty slow and also fairly expensive. And so for both of those reasons, a lot of my clients come in with the sole goal of, I don't want to go through court when I die. I want my kids or my other heirs or my charities to get the property as quickly and easily as possible. So a big goal for a lot of people is keep it out of court. You might have some protection of your assets, of your decisions. And then the last couple here are kind of the same, but you create a roadmap and also some family directives. So, this child is my healthcare person, where this one is my finance person. And then what do you do at what times? It just really gives guidance to your family so not scrambling in the event of your incapacity or your death. What types of things can you control? First, who makes your healthcare decisions? I'll go over what document that is here in just a second. Separately, who do you want to make your financial decisions if you can't do so? If you're in an accident, you may have different people that you want to rush to the hospital versus talk to Everhart or your accountant or your lawyer. And so you separate those into two different categories. Third, who gets your stuff? If you pass away, is it equally to your kids? Do you have friends or charities or other individuals you want to inherit? And then a big one, if you're like me and you've got minor children, your estate plan's also where you say who raises them. So in my case, if my wife Lauren and I both pass, we want to know who's going to take care of our daughter. So our will is what says who raises our daughter until she turns 18. If you have a child with a disability, that can even extend beyond 18. You can say, my child, who I'm the guardian of as an adult, I want this person to raise them when I'm not here. Not really if, but when. And then last but not least, who wraps up your affairs? It's what we call an executor and executrix. Some states call that a personal representative. Those are interchangeable terms. In Florida, for instance, where we also do a lot of work, they call it a personal representative, but I'm going to use the phrase executor for today's presentation. The main documents we're going to cover today, and there is a separate slide on each of these, and the slides are available, so don't feel too pressured to take down notes. But first, we're going to talk about durable general powers of attorney. Second, I'll cover healthcare powers of attorney. We'll also cover living wills. I will note some states call that advanced directives, and I'll explain what those differences are. We'll talk about a last will and testament, which does three main things. And then finally, we'll briefly cover trust. Trust could be its own class, a whole day lecture probably, but I'll try to give you at least enough information to decide if you need a trust for some purpose. Digging into each one of those individually, the first one I mentioned is the durable general power of attorney. This is what most lay people just call a financial power of attorney. It's a document that allows you to say in advance, I want some other person to manage my financial affairs if I'm unable to do so myself. The benefit to this is you can say in writing, if I'm in an accident, rather than my family going to court and asking for control of my affairs, I've already said it's my sibling or my parent or a child or my spouse or someone who can do all my financial things. And it's typically a comprehensive document. So the terms there in the title, durable is what you want. A durable power of attorney is one that lasts whether you're in an accident or not. So that's pretty much a no-brainer. The only time you wouldn't do a durable power of attorney is if it were for a limited instance. If you were saying, I want my friend to go to the bank on this one day to do this one transaction. General, the second word, there's also important. So they're comprehensive. A general power of attorney gives someone the power to deal with everything from taxes and bank accounts and retirement accounts and real estate and all of the financial things in the world. Whereas a specific power of attorney might say, I give someone the power to go to this real estate closing. It's only good today and it's only for this one property. You want a general power of attorney, so someone is waiting in the wings to take over if you can't do so yourself. And the real benefit there is you avoid court if you're in an accident. A totally separate document in every state is a healthcare power of attorney. Similar in concept that you're saying in advance, if I'm in an accident, who do you want to make your decisions? In this case, the decisions are healthcare related. So who do you want to be able to go to the hospital, talk to your doctor, say yes or no to treatment, etc.? This also avoids getting the court involved by seeking a guardianship over your person rather than your estate. Pretty much every state makes these publicly available. If you Google based off what state you live in, here, Ohio Healthcare Power of Attorney, you're going to find the standard form. Almost every hospital is giving these things out nowadays. They're very available online. Here we have standard forms. Pretty much every state does. So at a minimum, go online, download these. They're relatively simple to fill out. I, Jeff, say I want my wife, Lauren, to make my decisions if I can't talk to my doctor. My daughter's not old enough yet. So in my case, I've got my dad named as a backup. But you pick the right people in the right order, and it gives them all the powers to make your medical decisions. In Ohio, we have a separate document for end of life decisions, which we call a living will. Many states either combine this into the power of attorney or they call it advanced directives. But you're also allowed in pretty much every jurisdiction to say in advance, while I have a power of attorney who gets to come to the hospital and make my decisions, you may not want them to have to pull the plug, so to speak. So, an advanced directive or a living will, as we call them, allows you to say, if I'm in a certain medical condition, which is typically governed by your state, here in Ohio, the standard is if two doctors say to a medical degree of certainty that you are permanently incapacitated in a vegetative state, then you can pre-authorize saying, if that happens, I don't want to be hooked up unnecessarily to extend or prolong my passing. I want to be allowed to pass naturally once these named people say goodbye. So what it does is it takes the burden off of your family. Rather than your son or your daughter, someone having to pull the plug, you can say, if it's medically certain, I want to be allowed to pass. And you sign that in advance. Different states have different options there, but each state has their own form for these. Some states, like here in Ohio, there's even a box on the form before they want to be an organ donor or not. And so you can fill that out at the same time. You can also do that at the Bureau of Motor Vehicles here in Ohio. That's the only registry we have for organ donation. Any questions on the power of attorney documents, Bree, just while I'm here before I get into wills?
Yes. One person asked, can you have two health POAs, one local, one long distance, one emergency versus chronic?
Yeah, great question. So here in Ohio and in every state that I'm aware of, you have two different ways you can name two people. Um, Both are technically allowable. One I prefer. So one, you can have co-agents. These two people each have the ability to do this. So I've got two kids, and son and daughter both have the right to do it. Or you can do an order. You can do an A and a B rather than together. And so you could name them as co-agents. That way the local one can get there and the faraway person can't. The rub with co-agents is if they don't agree on something, in particular, if there's only two of them, I can't break a tie when one says yes and one says no. And so that could lead to complication about do we do the treatment or not? And then, so what I would prefer is, I've got person A, and if that person is unable or unwilling to get to the hospital, then it defaults to person B. But absolutely, you can figure out what works best for your family and either pick them together or one and then the other. So, great question.
And then we have another question. How often should we revisit and update an existing plan? Every year, every 5 years?
Yeah, great question. And someone somehow cheated ahead and saw the slides. I cover this later, but every year is probably too much. Every 5 years is probably okay. My recommendation is 3 to 5 for my clients. If you signed your documents today, I follow up in 3 years to look back at them. Um, any of those is better than what I see a lot of where people walk in saying, I wrote these things 30 years ago and I don't even know who the lawyer is or where to find them. So I think 3 to 5 years is a wonderful timeline, or those big life events. If someone who's named you have a falling out with, or they pass away, or they've moved, or something along those lines.
And then does the durable general power of attorney only come into play when incapacitated?
Another great question. So there are two types, and some states allow both, some states don't. In Ohio, you can do either. In Florida, you can only do one, but technically there are two versions. So there's one that is what's called springing, which is what your question suggests. I give the power to this other person, but only if I'm determined to be incompetent. So the power springs to that person if I'm if a doctor says I'm incapacitated or I'm adjudicated incompetent or something. Those sound nice, but what has happened is doctors don't like to sign off saying you're incapacitated. And so those are really hard to administer. So some states, and Florida's the big one, have said, we're not going to do that. We only do immediate powers of attorney. I pretty much only do immediate powers of attorney myself, even though technically you can do springing in Ohio for the same practical reason that it's very hard to get a doctor to sign a letter saying Jeff's incapacitated and can't manage his money. They feel that's not their place to step in and say that. And the alternative then is you go to court, and the whole point of the power of attorney was to avoid court. And so my strong preference is to do an immediate power of attorney. And some people are then tell me push back and say, Well, I don't want to give this person the power today, but if you think about it from the other side, if you don't trust them today while you're competent and can oversee what they're doing, I'm not sure why you would have more confidence that if you've been in an accident and you're incapacitated, then you want some other person to take over. So the immediate type is pretty strongly preferred in most jurisdictions. But depending where you live, there are those two varieties. That cover them?
Yep.
Okay, great. We'll move on to wills then. And then same thing, if you have questions about this section, punch them in and Bree can read off ones that she thinks are good for the group. If they're crazy specific or something, you can hold them and I can always email follow up to people after the fact. So those are the first three. I call those disability documents. The other side of your estate is what happens when you pass away. The simplest way to do that is with what's called a last will and testament, which does three total things. First, they say who gets your property. Sometimes that's super broad. I give 100% to this child or 50-50 to these two kids. Sometimes it's very granular. I want my car to go here and my house to go here, but that's really up to you. Second purpose of a will, who's your executor? Who do you want to carry out what the will says? This person doesn't have to be a beneficiary, but they are the one doing the bulk of the work. So the executor is the one who sells your house, sells your car, files your last tax return, closes your accounts, all that stuff. And then the third thing is a will can appoint a guardian. So that's where you say, if I've died and I have a child who needs someone to raise them, who would you like it to be? That is just a nomination, but it's really important if you've got minor children or disabled children to put in there that you want it to be this friend, this couple, etc. The way most states work, if you name a guardian in your will, it can be anyone you want. It can be friends, it can be neighbors, it can be people in your school district. If you don't nominate someone in the will, then the court is just going to notify your closest family members. And so that's going to be typically the grandparents, maybe the siblings. They may or may not be the right fit. So, particularly if you want to name a friend or someone in your school district or something, really important to write down who you want that guardian to be. And of course, if you're married, both spouses need to have the same answer put in their will for who would raise those kids. Technically, in a lot of states, you can also put that in your power of attorney, saying if I'm disabled, here's who I want to be the guardian for my kids as well, and that is in the Uniform Power of Attorney Act that most states have adopted. There are some big advantages of a will versus having nothing. Big ones, what we were just talking about. You get to nominate who you want that guardian to be. Second, doing a will allows you to leave your property wherever you want. There are certain requirements in most states to leave a certain amount to your spouse. But beyond that, you have the freedom to leave your property wherever you want. So if you write in a will, you want it all to go to your church or your favorite charity or your alma mater or something, that's perfectly fine. If you don't do a will, then the state you live in decides where your property goes through a series of what are called intestacy laws. And those can get a little strange. They try to go to your closest family member, but I've had plenty of cases where someone totally unknown can inherit the property because they're technically the closest family member. So here we follow basically your spouse is your closest family member, then your kids. If you don't have a spouse or kids, it's your parents, then your siblings, nieces and nephews. Next in line would be grandparents, aunts and uncles. And there's this chart called the table of consanguinity where you can look up and see who the closest relative is. But what can happen if you have no will is it might leave it to someone who you don't want the property to go to. Or worst case scenario, probably, if they can't find a relative, then the state actually inherits the property. Every now and then you see a big one. There was one in New York a few years ago where someone with millions and millions of dollars didn't have any relatives. And so the state got his entire property. Third big advantage, you can make specific bequests. So you can leave a certain amount to church or charity or certain items. I want my car to go here or whatnot. If you don't put that in your will, the state you live in is never going to give specific items to anyone in particular. So you have to carve that out. It also saves a lot of expense. In a supervised probate state like Ohio, wills these days have grown in length. If you have an old will, it's probably 1 or 2 pages. If you have a current one, it's probably 6 or 7 pages or more. The reason is you now put clauses in your will saying, I give the people named the power to sell my car and sell my house and deal with my stocks and my bonds and my 401k and all the things. If you have those clauses, then you don't have to go to court and ask permission. So if the will says you can sell the house, then you can just sell the house. If it doesn't, then you end up going to court and asking for permission to sell the house, the car, the boat, whatever it is. And then last but not least, in a lot of states, like here in Ohio, if you write a will, you can name any competent adult to be your executor, regardless of where they live. If you don't do a will, Ohio says that they have to have what's called an administrator, Very similar role, but the rub is that administrator has to be an Ohio resident. And so what happens if you don't have a will and you have no family here? You may have a sibling or a parent or someone in a different state. They can't serve because you didn't name them. So Ohio has to pick someone local to do it. So oftentimes it ends up being someone like me. The court will appoint a lawyer or someone to do it for you when you may have preferred it to be a parent or a sibling or a friend or someone. So really important to name who you want to be that executor. Without a will, as I mentioned, the state determines where your property goes. The first thing they try to figure out is, are you married or not? Because there are certain requirements to leave a certain amount to a spouse. If you don't want to leave your money to a spouse, you can technically use some workarounds like PODs and TODs and beneficiaries. In reality, if you don't want to include your spouse, you probably ought to be talking to a divorce lawyer, not an estate planning lawyer. But when they ask the question, were you married or not? The question is just, were you legally married? I've had, unfortunately, a couple of cases where someone was contemplating or even going through the process of a divorce, but it wasn't finalized when they died. And all the state's going to ask is, were you married or not at the time of your death? Couple examples here in Ohio, and I went over these briefly, so I'm going to kind of breeze through this. If you die in Ohio and you don't have a spouse, but you have kids and no will, they assume you wanted to go equally to your kids. A lot of times that's the right answer. May not be. You sometimes kids need more or less, or someone is not in the family anymore. Um, if you've got no spouse and no kids, this is the strange one here, and a lot of states do this as well. They leave it to your parents. I have plenty of people who say, well, my parents don't need this, or maybe my parents are in a nursing home and Medicaid's going to take this or something. But in Ohio and a lot of states who have the same chart, if you've got no spouse and no kids and you die without a plan, they give it to your parents, which, like I said, isn't usually the right answer. If no spouse, no kids, no parents, siblings become the next closest relative. And then from there, it follows that chart that I mentioned. Some stranger ones here are for married folks. As an example, if you don't have a will and you die in Ohio and you're married, and all of the kids you have are the product of that marriage, let's call that a traditional family unit. You've been married one time and have a couple of kids who are from that marriage, and you die. The state assumes you wanted to leave everything to your spouse, which often is the right answer. Where it gets a little crazy here in Ohio is if you're married, but it's a second marriage. So, as an example, if you get married, but you already had one child from before your marriage and you were to die, they want to protect your prior child from the stepmom or the stepdad. And so to protect them all, they divvy it in half, basically. Your current spouse gets half of your property plus 20 grand. Your child from before gets the other half of the property. And then what's really wonky is if you have more than one kid. So if you have two kids from before and you get married, they give those two kids two-thirds of your property, and your surviving husband or wife only gets one-third of the property plus 60 grand. I have a lot of people who one-third of the property doesn't even include like their house or enough money to live on. So this could be really difficult for a surviving spouse. The point here is if you do a will, you can leave it wherever you want. I've never had anyone walk in and ask for this, but this is what happens in Ohio if you don't have a will. And it happens very similarly in pretty much every jurisdiction. Last thing on this before we get into trusts, the way you have title to your property will determine whether your will actually governs it. So wills only cover property that goes through probate. Probate property is a very hard concept to define. And so I think it's easier to sort of work backwards and tell you what is not probate property. First category, if you have a jointly owned asset and that asset has what's called rights of survivorship, it does not go through your will. So, for instance, if I have a joint checking account with my wife, which I do, and I were to die, my joint checking account becomes my wife's property, regardless of what my will says. My will could say I want it all to go to the Buckeyes because I'm a proud alum, or to a church, or to a friend, or all to my daughter, or literally anything else. But the joint property goes to the joint owner. Usually that's a great tool when you're married. Leave everything joint to your spouse. You don't have to file the will. You don't go through probate. But you need to know joint property does not get governed by your will. It goes to the joint owner, whether that's your spouse. You can have joint property with a sibling, a friend, a business owner, anyone. Second thing that doesn't go through probate is things with beneficiaries. So if you have a life insurance policy, everyone on here should have a retirement plan. Those things have beneficiaries built into them. So if your contract with your life insurance provider or your 401k provider says, upon my death, I want the proceeds from this policy or this account to go to this person, it goes directly to them. Now, this is a useful tool. You can say, I don't want my will to be filed. I don't want to go to probate at my death. I want it to go to my spouse or my kids or someone. But it could also frustrate your plan. Your will could say it goes to your two kids, and your 401k says it goes to one kid. Well, the one kid gets the 401k regardless of what the will said. And so you would have to be very aware of what your beneficiaries are. And then last but not least, anything that's either payable or transferable on death also goes directly to those people. Payable on death is for financial accounts, your checking, your savings, a lot of CDs. Banks have those types of tools. And then transferable is typically for physical assets. Here in Ohio, you can TOD basically anything. If a car is paid off, you can add a transfer on death by going to the Bureau of Motor Vehicles and saying, I want this vehicle to be transferred to this person when I die. You can also transfer on death any real estate here in Ohio, and most states allow for transfer on death, either affidavits or deeds. It's not quite all 50. My real estate paralegal keeps a running list of who does or doesn't have it. So if you have specifics, you can ask. But those are all really good tools, but they might conflict or not agree with what your will says. So you have to be aware how to use them. But this is sort of also the DIY page. You can do a lot of this, particularly if you want it all to go to your spouse or if your kids are grown and responsible. These are great tools. These aren't necessarily good tools if the people have died or you don't trust them or they can't manage the asset or the money, but great starting point for folks as well. From here, I'm going to get into trust, but before that, I'll pause again just to see if Bree has any questions that she think would be good for the group.
Nope, you can keep moving forward.
Great, we'll keep rolling. So another alternative to wills are to use trusts. And again, as I mentioned, this could be its own lecture. But I'm going to try to give you a primer so you at least have an understanding of what is a trust. Do I need a trust for some reason? The answer is not an automatic yes. It really depends on your family circumstances. So at its basic level, a trust is a private agreement between a couple of parties. The person who creates it is typically called a grantor, though we'll note some states call it a settlor. Here in Ohio, the person who puts the property in is the settlor. In some states, they use those terms interchangeably. Usually, if I create a trust, I'm the only one putting property in. If you guys on the call want to put your property into my trust, that's okay by me, but that's not usually the way it works. It's typically you put your own property into your own document. The other party to a trust is the trustee who's in charge of it. For a lot of trusts, that might be you. While you're competent, you create your own trust and you're in charge of your own trust. It might also be a third party. I see that most common for people who are aging or don't want to have control, or they're giving assets to kids or grandkids or something along those lines. And then the trust also has rules and beneficiaries. So it might say, while I'm living, I'm in charge, but if I died, I want it to go to these children or these other people, which could be outright or it could be held for their benefit, depending on whatever the document says that you've created. And there are a lot of reasons why you'd consider it that we'll go over. There are two main types. Depending where you live, you may see either of these. So one variety is what's called a testamentary trust. So you write a last will and testament is where that word comes from. And it says in it, if I've died and some condition exists. So if I've died and my daughter's not 18 yet, then I would like someone to create a trust for me to hold the money until she becomes an adult. The other variety is what's called a living trust. You actually sign the document today. In many states, including here in Ohio, we prefer the living type. And the reason is because the will created it. In most places, it goes through probate. So if one of your goals of creating a trust was to stay out of court, you don't want a trust that has to go to court. So the testamentary type are not nearly as popular, though I do see them out of New York still sometimes. I've seen a Texas one recently. So I know there are still some states where these are popular. But by and large, you want a living trust, meaning you create it today. And then from there, the two main subtypes are a revocable type, which we're going to kind of focus on today. That literally means the person who creates it can make changes. So I can amend it, I can get rid of it, I can do whatever I want with it. The other variety is an irrevocable type. Those typically can't be changed or completely revoked, but there's usually a trade-off. I give up the right to change this, but in exchange, maybe it saves me money on taxes or helps me qualify for Medicaid or helps the government pay for the nursing home through the Department of Veterans Affairs or something. So those are your main sub-varieties, but we're going to focus mostly on revocable trusts. We typically do one of these EAU sessions on elder law planning as well every year. That'll be more of the irrevocable type. So if you've got parents or loved ones who are trying to figure out how to pay for the nursing home, that's a different lecture that we also help cover for EAU. So just tune into that one if you're wondering about those. Funding is the process of putting things into your trust, and that happens in one of two ways. One, trust can literally own pretty much anything you or I can own. So the easiest thing is to retitle. So you can walk into the bank and say, hey, Chase, I want my account to be in the Kunkler Family Trust rather than in Jeff Kunkler's name. And they just change the name on the account. You can do the same thing with real estate, with cars, etc. The other method of using a trust is by beneficiary. So you can certainly have a will that gets it there. It's called a pour over that says, if I've died, put my estate into my trust. We do those all the time. Or by beneficiary. I want this life insurance policy, this 401k, this brokerage account, this something to go to my trust if I've died. And those are all effective ways to get things in there. Who's going to be your trustee is important. There are two options here as well. One, and by far the most common, is an individual. I want a friend, a sibling, a child, a parent, someone to manage my trust if I'm unable to do so. The benefit in picking an individual is they're typically a family member or a friend who knows a lot about you and your values and can carry out your wishes. Sometimes there's no obvious choice. You don't have a child who's old enough yet. You don't necessarily want to trust a parent or a friend. And so the other option is to use corporate trustees. Those are professionals. Most of your larger financial institutions, all of your banks generally have companies that can be the trustee for you. Um, while they don't know your family, they probably do know a lot about investing. They probably know about filing taxes. They probably have, lawyers and accountants and other folks like that on staff. So those are your main choices. The downside on the corporate, they typically charge a fee, whereas your child or sibling or parent may do it for free. But worth exploring both of those if you're going to set up a trust. Main reasons to use trusts, and just like the slide from before, I kind of did this Family Feud style, but instead of Forbes writing it, this is what I see in my personal practice. So the number one reason we're writing trusts these days is that it benefits kids who aren't old enough to inherit. Now that could be they're literally minors, they're not 18, or young adults. I had people in yesterday who have three kids, all over 18 but under 25, who said, if we died tomorrow, we're not sure these college age kids are quite ready to inherit all of our life insurance, our house, our 401k, et cetera. So a very common reason to do a trust is to say, I don't want the court to hold the money for my kids. And maybe I want to go beyond 18. A very common age frame that we do is to say someone manages it for your kids until they're maybe 25 or 30, or even in chunks, 25, 30, and 35. But make sure kids don't inherit money too young is by far the most common reason. Second big reason to use a trust is it's private. So unlike a will that goes to court, which is publicly filed and anyone can read what your will said and how much money you had, a trust is private and does not go into court unless there's a lawsuit involved in some sort of dispute. Third, if the people you're leaving the money to might have creditor issues, you can protect them with a trust. So if you do a will, at the end of your estate, they basically cut a check to the beneficiaries and say, here's your money, good luck, it's yours. And if that person subsequently gets sued, files for divorce, files a bankruptcy, or any sort of a liability, they're exposed to that. A trust, on the other hand, could say it's held in trust for your life, and the trust itself can't get a divorce. It won't be sued. It can't file for bankruptcy. And so some people create a trust just because they're worried about a son or a daughter-in-law, or their kid's in a risky profession, or doesn't have good finances or something. And so no, that's probably the third most common reason. Fourth, if you have a child or grandchild with special needs, you absolutely need to consider a special needs trust to make sure they can get their benefits from Medicaid, SSI, et cetera. I do a lot of work in that space due to some charitable affiliations, but if you've got a child with disabilities, you absolutely need to create the right type of a trust for them. You might save some money on the estate tax as well. And then last but not least, and I get quite a bit of these, if you just want to go outside of probate, trusts do not go through probate. And so anything that's in your trust isn't subject to court jurisdiction. And so for some people, even if their kids are old and responsible, they just don't want to pay the expense and go through the time involved in going through court. And so they do trust just to minimize or avoid that. Before I dig into taxes, any questions on that realm, Bree?
Yes. What if a spouse or I am widowed and end up in a nursing home? Do my assets need to be in a trust to prevent assets such as home being taken by nursing home?
Yeah, great question to which I could talk to this person for probably an hour. An irrevocable trust set up correctly is a great tool for that exact circumstance. If you're in control and in charge of your trust, the government would still say it's your property. So a lot of your garden variety revocable trusts you don't have nursing home protection from. But the right type of an irrevocable trust absolutely can help shelter assets from Medicaid. And the question hit exactly what we see most often, which is that people often use that to protect their house. It's a big asset. Often it's paid off. You don't need your house to pay your bills monthly. So if I get it out of your name in the right kind of a trust, it's a very popular way to protect that asset from the nursing home. That person I would definitely encourage to attend the elder law seminar when you guys cover that here at EAU. But yes, there are absolutely trusts that would help protect those assets. There are certain rules and timelines and lookbacks that we don't have time to cover today. But great question. Feel free if you want to talk more about it, follow up with an email or phone call to me, or if you already have a lawyer, whoever that person is as well.
Then, are there disadvantages of choosing all three of our children as the trustees for our trust?
Yeah, kind of same thing with the healthcare decision. Three people is three people that I need to do the task. So I'm going to have three people, sign checks and attend the real estate closing, and three people to have to agree on, do we just sell the house as is or do we fix it up or not? So my preference would be that you have child A who's in charge. And if he or she is unable or unwilling, then B is the backup, and then C is the backup to the backup. And you can list them all. You can have as many backups as you'd like, but three co-trustees could be administratively difficult. There's just a lot of people who have to meet with the lawyer or the accountant who have to sign the paperwork. So technically permissible, but I would want to talk through the complexities involved there. But yes, you can have as many co-trustees as you want. But when you think through it, it might actually be causing more difficulty by going that approach.
Can you share why someone would do a will instead of a living trust?
Yeah, I would say I see it if they're not concerned about the cost and the time involved with probate. Maybe it's a small estate. The people they're leaving to it aren't in need of managing. I have some people who don't have family members they're leaving it to, and so they don't really care if it takes longer or costs more because they're leaving it to their favorite dog rescue or charity or church or something. But I'd say I see it most common either really young. I just had a kid, and my main goal is naming the guardian. So very popular at that age. Or I don't really have that much to leave, and I've done a lot of beneficiaries on my IRAs, my 401s, and whatnot. And so I don't think the will is going to do that much. So it's kind of a backup. Um, but by and large, when you talk through it for many, many people, I'd say most of the people, a vast majority of the people I see, do come to the conclusion that a trust will end up saving their family some time and some expense. But we do some simple wills. I probably, if I do, I don't know, 150 plans a year, probably 10 of those are simple wills. So they're not unheard of, and they could be the right fit. I just had a meeting yesterday where I think that's what we're going to go with for someone. So it's not unheard of. But in a lot of states, particularly in Ohio, where probate is so slow and so expensive, it tends to be something we try to avoid.
And then last question, do you have to have a trust to avoid probate or just a will?
So wills go through probate, but you can avoid probate with those other tools. So the non-probate slide, the joint property, the beneficiaries, the POD, the TOD, those avoid probate, but wills go through probate.
That's it for now.
Okay, I'm going to try to get through taxes pretty quickly here. These are great questions, and I would love answering them, but I got to kind of keep with the pace. So, for taxes, good news here in Ohio, and this is the case in most states. We no longer have an estate tax. Here, it's been gone since the 2012. Back when we had it, we had the lowest threshold in the country. If you died in Ohio in 2011 or 2012 and you had more than $338,333, which is a strange number, Ohio got 6% of your estate above that. And then at $500,000, it switched to 7%. There's about 10 states left that have an estate tax. Here, we don't have it. Certainly, while DeWine's in office, I don't see it coming back. I don't know whether it's going to be Acton or Vivek, but stay tuned to whoever the next governor is. And then federally, this is where a lot of people tune me out. We have pretty favorable rules right now as well. So President Trump extended his tax laws and their index for inflation. So they got very favorable as of January 1st of this year. Couple things to know. First, you can leave an unlimited amount to a spouse who's a citizen. So you can leave $1 billion from spouse to spouse as long as they're a citizen. To a non-spouse, whether that's a non-citizen or more likely to your kids or someone else, you don't pay a state tax in the US unless you have more than $15 million. And this is why a lot of people stop listening to me at this point. If you have $16 million, then you pay tax. But if you had 14.5 million, no tax currently owed, that will go up a little bit every year while Trump's still in office. the next president may very well change these. This has changed probably 10, not 10, probably 5 times in my 16-year career. So basically, every president rewrites the tax laws, but the current rules are very favorable. If you have more than 15 million, it's a 40% tax. So if you had 16 million bucks, that extra million gets taxed at 40%. You'd owe four and a grand to the IRS. So the very, very wealthy really want to avoid this tax because it's one of the steepest rates we have. And then if you're married, you can actually double that amount. So by filing a special tax return, any married couple has a $30 million limit in effect. When the first spouse dies, you do have to file a return with the IRS. We do a lot of these. If you're in that category and your spouse dies, just work with your accountant, whether that's Tom at Everhart or you've got your own outside person, but work with someone to make sure you understand those rules. But it's very favorable this year. The other tax to cover is the gift tax. The way it works in our system, and again, this works better in person for a show of hands, but in our country, if you give away a large amount of money, you actually pay tax, not the person you give it to, and it's synced with our estate tax. This year, you can give $19,000 to anyone you want without telling the government that you've given the money away. But if you go beyond that, it does impact your estate tax. And here is how that works. So first, you can give that 19,000 to anyone you want every year per recipient. So if you have two kids, you can give two $19,000 gifts every year without reporting it to the IRS. A trick is that's per person. So a married couple can give 38,000, and it doesn't have to be literally two checks for 19,000. There's something called gift splitting. So mom or dad can give $38,000 to each kid, each grandkid, etc. If you go beyond the annual limit, they take away from your death limit. So, as an example, if I was single and I gave someone $20,000 this year, I would have to report it to the IRS. And they would say, you went $1,000 beyond your limit. So now they would say at death, rather than 15 million as an exemption, I have 14,999,000 as an exemption. I wouldn't pay tax, but I am required to report that to the IRS. So for most people, they're not actually going to pay any gift tax, but it does take away from your death exemption. There are two exceptions to that. You can pay an unlimited amount for someone's health care or their tuition if you pay directly there. So if I write a check to Riverside Hospital for 100 grand for someone's surgery, that's okay as long as I paid Riverside directly, not paying the person who turns around and pays Riverside. Same thing for college. Unfortunately, there are not a lot of colleges that are less than $19,000 a year anymore. And so if you want to help pay for a child or a grandchild's education, you can do that, but you want to write that check directly to the institution of education, not to the grandchild. And I don't know of any state that has a gift tax, but here in Ohio, we've never had one. That's only a federal rule to keep in mind. Any tax questions before I kind of get into some of the wrap up and take home items? Probably not, but
Nope.
okay. Very common that everyone hits mute at that point. So sort of things to keep in mind. If at some point you said, oh, I need to do one of those things, how would I find a lawyer? Few tips. One, we're all kind of specialists these days. So at my firm, there's 30 or so of us. We all have 30 or so unique practice areas. So I would go to the lawyer who does what you're doing. If you need someone for a real estate dispute, hire a real estate lawyer. There aren't so many just general practitioners anymore. We're a lot like medicine where we're very specialized. So if you're interviewing, I would find out, how many plans they're doing a year, how long have they been doing, and then you want someone who doesn't just write them, but they also deal with on the back end. You learn a lot about how to do an effective plan once your clients unfortunately start passing, and you have to actually see them through the court or the IRS or wherever. If you don't know who to ask, Everhart's a great starting point, but ask your financial planner, life insurance agent. You can ask an accountant or a friend. I have like neighbor and stuff on here. I can't really imagine like checking the mail and asking my neighbor who their lawyer is, but certainly, asking around is a great way. Facebook's become more popular. I get a lot of leads from in my particular suburb of Powell, Ohio. There's the Powell Bubble, which is a Facebook group that people recommend lawyers for occasionally. I'm not in Dublin, but the Dublin where the office is for Everhart is, the Dublin Moms in the Know are a great lead for me. I get a lot of moms who give my name out, but there's lots of resources out there these days. You can also ask your local bar association. So there's both the Columbus and the Ohio Bar. Here in Columbus, the Columbus Bar Association used to have a referral program, but they're kind of reworking that right now. But whatever city or state you live in, if there's a bar association, there's usually some sort of a referral list. I would note there's typically no barrier to entry. So if you want to be on the bar association referral list, you just tell them you want to be on it. They don't actually ask How long have you been practicing? Do you know what you're doing? Make you pass a test or anything, but that is a resource as well. Sort of next thing to discuss, and I would discuss this before your first meeting. How is the lawyer you're talking to about this going to charge? There are two ways lawyers charge for their time. The old school way is hourly. I do have an hourly rate where I bill you per minute that you talk to me. Very common in cases that we don't know how long they're going to take. So if you want to sue your neighbor, I don't know whether they're going to fight back or not. So it's hard for me to guess how long that's going to take. So I typically bill you hourly for that dispute. What most estate planning law firms do these days is charge a flat fee. You need a will and a power of attorney that costs X, or you need a will and a trust and both powers of attorney that costs Y. The flat fee is a really nice approach. That way, you as the consumer know what it's going to cost, and you don't have to worry that if you make an extra phone call or an email, that it's going to increase your price. This tip, I always said discuss the fees at the initial meeting. That was always true until recently. I would say there are more firms here locally who charge you just to sit down for the consultation. And so I would ask this question when you're scheduling the meeting. Am I going to pay for that initial sit down or not? For me, if you come from Everhart or someplace like this that I speak, I don't charge for people to have that first meeting, but there are people who charge a consultation fee. So just make sure you don't show up and they're not a good fit and then you get a bill in the mail anyways because they charge a consult fee. So something to discuss probably before the first meeting. Top 10 tips. If you're going to print one slide, this is probably it. One, do the disability documents, do your healthcare, financial POA, your living will or advance directive. Everyone needs it. Even college kids. I just yesterday had an accountant whose oldest is going off to college in not a couple months, in a month, say, my son now needs these documents. I said, yes, he's 18. He needs the living will, healthcare, financial POA. So if you have young adults or yourself and don't have the disability documents, absolutely get them. They're very easy. I would work with a lawyer, but even if you don't want to, you don't want to pay, they're pretty available online. So just Google it. Second, you need a will. Even if you have a trust, you do a pour over will. Even if you have a small estate, you should at least have a will saying where you want your property to go. If you've got little kids, absolutely, you have to have a will because that's where you name the guardian. Fourth, pick the best executor. I have a lot of people who just tell me I'm going to pick my oldest child. Pick the best person. So someone who's very good with record keeping, finances, can interact with a court, etc. Fifth, if you're just going to roll the dice, remember your state picks where your property goes. So if you have certain wishes or goals, you need to put that in writing. You can't just let your state figure it out. Six, if you got little kids, trusts are a wonderful idea. We don't generally want the probate court holding it for till they're 18 and then handing it all over on their 18th birthday. Both of those are bad outcomes. Seven, your ownership, your beneficiaries, all of that is critical to your estate plan. So you really need to know what beneficiaries you have, what's jointly owned, etc. As a general concept, if you're trying to avoid probate, you don't then want to make your estate the beneficiary of things like life insurance because that goes to probate. And so generally, you want to come up with some trust, some individual, some charity for those beneficiaries. Nine, where you live determines the estate tax. That changes every year. So you want me or someone like me to tell you what those rules are. And then last but not least, if you're doing big annual gifting, please work with a lawyer or an accountant before you're giving giant gifts. Generally, those are gone. I can't get them back if you need them. If you might need the money, there are other structures you could implement. And then finally, the life cycle I promised. So the stages here that might apply to you. Are you single? Perhaps you're in a committed relationship or married. Maybe you've got some kids or sort of closer to retirement. Are you in the golden years? People all the time are like, that was great. I don't know what I need. These are the next three slides to tell you sort of a check the box list. On the first side, if you're single, I would strongly consider all these documents. But if you're newly minted 18-year-old, it's probably not on your radar. I would at least do the disability stuff, the first three. Technically, every adult should have these, but I would consider until you own property and have a committed relationship, you can probably get by without a lot of these. As soon as you have a committed relationship, you got to check those first four boxes. That's what I sort of call the foundation of a plan. And then before kids, trust is sort of optional. Depending what you own and where you live, you would consider it, but not necessarily critical to that plan. As soon as you have kids, though, you check that box, have a trust that says what age do they inherit, who gets what amount, at what timing, who manages it. You may think about more specialized stuff. If there's someone in the family with a special needs, certainly you would create the right type of a trust. Dynasty trusts are sort of generational. If you've got enough wealth, we can make it that no one pays tax. Not only do your kids not pay tax, but their kids and their kids and their kids. And so there are some specialized tools to consider. By the time you retire, if you needed those specialized things, you check that box. And then one of the questions earlier asked, can I use a trust to protect my house from the nursing home? Yes. Once you hit that retirement age, I'd say 60 to 70 is a great window to look at, should I be doing a different structure to protect some of my assets from being spent down before Medicaid or the VA would start paying for an assisted living or a nursing home? If you carry a lot of life insurance, you would think about a life insurance trust at that point as well. To get started, this is sort of a team sport. The people you need, an accountant should be involved. That can be on the Everhart team or elsewhere. Financial planner, similarly, Everhart can do that for you. You may have a life insurance or property and casualty agent. I consider funeral planning a part of this too. Even when you have your documents done, I think it's wonderful to go pre-plan the songs, the readings, the funeral, buried or cremated, all that. And then certainly someone like me should be a part of that team as well if you're a estate planning attorney. A question came up earlier on upkeep. I like every 3 to 5 years. As I said, my practice is 3 years, or if big ticket events apply. That same Forbes article I referenced earlier had the 5 Ds, and I also like mnemonic devices. So their recommendation was that there's been a death, divorce, a diagnosis, a decline in health, or a new decade, you should review your plan. I really think 3 to 5 years is a wonderful interval. For a lot of my people on their first 3 year review, they tell me nothing's changed, and that's great. You pat on the back, I'll see you in 3 years in the future. Most people don't need to see their lawyer every year or multiple times a year unless something big happens. So that 3 to 5 is usually a good window. And then I think I'm right at our hour. But to the extent there are more questions, the last slide here literally just says questions. But I'm going to go ahead and skip that and put up my contact info. If you have questions and want to keep putting them in the chat, Bree and I will field as many as you want. If you have something that was private and you don't want to disclose or anything, Max, who usually organizes these, wanted me to point out that one, you can contact me directly. So if it's a legal question, yes, you can contact Everhart, but they're probably just going to forward it to me anyways. And so if you want, that's my address and phone number and email. My headquarters where I'm sitting right now is in Grandview, but we also rent from Everhart. So we're in the same building up in Dublin. I spend a lot of time up there. I'm actually going to be up there in about an hour. But if you wanted to stop by, that's where I take meetings. My direct line is that 228 is the 628-0806 number, or my email is probably the best way to get a hold of me. I spend a lot of time doing these types of educational workshops and with clients and whatnot. And so if you're good with email, that's probably the best way to track me down. So I realize we're at 11 and need to wrap up, but I will field as many questions as we have. If you need to jet or run, this has been recorded. You can relook at it in the future. On behalf of Everhart, certainly thank you for taking the time and attention today to attend. Please look at the rest of their menu. They have a wonderful slate of options available. And if you have personal stuff that's not legal you want to talk about, they can also talk about your personal finances, saving, investment, all the many things they do. So I'll turn it back to Bree to field questions and keep firing them in the chat. I can stick around as long as people have questions, but we'll take no offense if people need to start dropping as well.
One person asked, would you recommend using an estate planning attorney who's in the same state we reside in?
Yeah, almost certainly, at least licensed there. So licensing rules basically say, like for me, I'm only an Ohio lawyer. So if I meet you in Ohio, you can be my client. And if you move, I can keep helping you. So because of that, I've helped clients in a lot of places, but there's a little bit of nuance from state to state. So you probably want someone in your local jurisdiction as a starting point. I think that's a good rule of thumb. For a firm like me, we have a lot of people who are not only in Ohio, but don't like the winters in Ohio. So they go to Florida for part of the year. So we are a Florida licensed firm in addition to Ohio. But if it's any other state, with a couple small exceptions, we don't do a lot of work there. So you probably want someone in your local state. Absolutely.
And then what is best if you have property in two different states? Can a will still work?
Yeah, great question. So will probably is even less efficient in that case. So a probate estate, the real estate is governed by the state where it's situated. So I have one of these right now. I just finished in Ohio State for someone. They have their parents had a lot out in the Phoenix area in Arizona. So the Arizona lot cannot go through the Ohio will and through Ohio probate. Now that we've finished Ohio, they have to go find an Arizona lawyer to deal with that lot. What would have been a great idea, and I didn't meet these people while they were living, would have been to use a trust instead. A trust can own property anywhere. So they could have had their Ohio property and the Arizona property in the trust and hired one law firm to help with the administration. But if you just have a will and go through probate, you have to open a probate, what's called an ancillary estate, everywhere there's real estate. And that happens both directions. I also have a big one right now where it's a California state, so they're doing most of the work, but they had one real estate asset here in Columbus. So I'm doing the ancillary estate just for that real estate here. So if you have property in multiple states, you probably need more than a will, is my take home for that person.
If I download and complete a Ohio Healthcare POA, what do you do with it?
Yeah, a couple things there. So, one, you can let the BMV know, and they will mark it on your driver's license. The current driver's license, and the reason to put it on your license is that first responders will know. So, like, I'm looking at my license right now. There's a little thing on the back of mine that indicates I have a healthcare power of attorney, a living will, I'm an organ donor. If you needed the squad to show up at your house, they're not going to check your file cabinet to see if you have these, but they do look for your driver's license. And so I would tell the BMV you've done these. The BMV doesn't take a copy, but they mark on here. That way, okay, the hospital staff sees yes, says Jeff Kunkler has a power of attorney. We know we need to try to track that down. And then second, I would also upload your documents, the living will and the healthcare POA, to whatever hospital doctor network you use the most. My chart seems to be taking over a lot of them. So, like here in Columbus, my chart is both Ohio Health and the Ohio State Network. You should take your documents into your primary care doctor and say, put this power of attorney into my chart. That way, if I go to the hospital, it's there. There's not a central repository though. So, like here in Columbus, if you go to Mount Carmel, I don't believe they use my chart. And so that's not going to get it there. But every hospital system and doctor system uses something these days for your chart. So basically, you can upload it to your medical files. That way, if you're there for an emergency and don't have time to bring your folder with you, oh, it's already in your files. And then I would tell the people who are named. So if you pick a kid or whomever, hey, son, you're my power of attorney. And if I'm in a hospital, here's where I keep the documents. Is it in a safe at home? And if yes, how do I get in that safe? Where's the key? What's the combo? If you use a safe deposit box at the bank, make sure someone has access to it. Those are difficult. Often, if you're disabled, no one can get in that box. So they are not my favorite place to put them. But telling the people both their name and where to get the documents, great too.
And then last question, what if the attorney is the executor and passes away? Who becomes the executor?
Yeah, so it would depend on what the will says. In my case, because I'm mortal, just like my clients, the way I write mine is you would say, Mr. Smith names Jeff as his executor. If Jeff is unable or unwilling, he names another partner of Carlisle, Patchen, and Murphy. So the will itself will hopefully have a backup that says if Jeff personally can't do it, it'd be one of his business partners. Not all wills do that. So the way it would work is if it just says Jeff and I am also dead at the time you die, and there's no backup, then there's no executor. The court would then default to an administrator, which would mean you'd be looking for a resident of your estate. And anyone, there's a sort of a priority. They give the priority to family first. And if not family, then anyone who lives in your state has the same priority. So it'd be worth reading your will if you've named your lawyer. Hopefully there's a backup. If they're not like me, where I'm at a firm where, there's a dozen of me who do what I do, if it's a solo, they may not have a backup. And so I would say maybe they have a suggestion for, a friend or another law firm or someone you could name to do that.
That's all the questions we had today.
Okay. Anything else we need to cover, Bree?
Nope, the slides will be sent out in the recording.
Wonderful. Well, thanks again, everyone, for taking the time to attend on behalf of Everhart. They provide tons of info. We're super glad you all took time out of your morning. If you have follow-ups and it's legal, contact me directly. You can also go through your advisor or contact at Everhart, and they can get you to me as well. So thank you all for attending and enjoy the rest of your day and week.